Ready, start. The appellants are aggrieved by order dated 25th June, 2013, passed by High Court of Karnataka Circuit Bench at Dharwad, whereby the regular appeal filed by them against the judgment and decree dated 16th September, 2010, passed by the Principal District and Sessions Judge has been dismissed. Full stop. Learned Principal District Judge reversed the judgment and decree dated 22nd December, 2007, passed by the Learned Civil Judge within bracket Senior Division bracket close, where under the suit instituted by the appellants for seeking a declaration to the effect that the appellant number 1 was the legally wedded wife of late Subedar Pundalik Bhave and the appellants number 2 and 3 are their legitimate children, was decreed in their favor, and it was held that they were entitled to the pensionary benefits payable by the respondents herein and standing in the name of the deceased Subedar Bhave. Full stop. Late Subedar Bhave was enrolled in the army in the year 1960. Full stop. On 17th July, 1972, he got married to one Srimati Parvati who died in about 2.5 years. Full stop. Thereafter, the deceased got married to one Srimati Ansuya. Full stop. During the subsistence of his marriage with Ansuya, he married the appellant number 1 herein. Full stop. Appellants number 2 and 3 are the offspring of the deceased and appellant number 1. Full stop. On 25th January, 1984, the deceased was discharged from service at his request and was granted service pension at the rate of 376 per month. Full stop. On 15th November, 1990, the deceased and Ansuya were granted a decree of divorce by mutual consent and he paid a lump sum amount of 15,000 to her. Full stop. Thereafter, the deceased approached the respondent number 2 for deleting the name of Ansuya and endorsing the name of the appellant number 1 in the PPO. Full stop. Subedar Bhave expired in the year 2001. Full stop. Thereafter, appellant number 1 approached the respondents for grant of family pension. Full stop. The said request was, however, rejected by the respondents on the ground that the deceased had got divorced in November 1990, whereas the appellant number 1 claimed to have got married to him in February, 1981, during the subsistence of the earlier marriage. Full stop. In 2005, the appellants instituted a civil suit for declaration, praying inter alia for issuing directions to the respondents to disburse the pensionary benefits payable on the demise of the deceased, Subedar Bhave. Full stop. The trial court decreed the said suit in favor of the appellants and held that they were entitled to receive the terminal benefits of the deceased, particularly, since no claim was ever laid on the said amount by his ex-wife Ansuya. Full stop. The respondents preferred an appeal, which was allowed, and the judgment and decree passed by the learned civil judge was set aside. Full stop. The said order was assailed by the appellants in a regular second appeal that came to be dismissed by the High Court. Full stop. Subsequently, the court clarified that the appellants number 2 and 3 herein would be entitled to the estate of late Subedar Bhave, which is in the custody of the respondents. Full stop.